General meetings are meetings of members of a company. And the Secretarial Standard 2 issued by the ICSI defines the same as meetings duly convened, held and conducted of the members of the company. Now, the power to convene such general meetings lies with the board of directors of the company or at their instructions or on the authority of the board by any other member. Usually a company secretary does that. Now, there are three important compliances for any general meeting. Number one, minimum 21 clear days notice before the meeting is being convened and classifying the items of business in the meeting into special and ordinary business and annexing an explanatory statement on all the special businesses transacted in the meeting or rather to be transacted in the meeting. So these are the three important compliances. Moving forward, an ordinary business are not defined in the Companies Act, but there are four such businesses which are considered as ordinary business, and by business we mean an item of business, that is an agenda which has to be discussed in a meeting. So those are: number one, appointing or reappointing directors of a company; number two, appointment of auditors; number three, adoption of financial statements of a company; number four, declaring dividend of a company. So these are the four businesses which have to be ordinarily dealt with in an annual general meeting of a company. Now that we understood what is an ordinary business, let's look into what is a special business. So special business is simple. It is a business which is other than an ordinary business to be transacted at an annual general meeting and any business which is transacted at every other general meeting of a company. So a special business is something which is not an ordinary business and that which is being transacted in any other meeting of a members of the company. So this is what is a special business. Now let's try to understand what are the kinds of resolutions which a shareholder passes. So there are two types of resolutions. Number one, ordinary, and number two, special. So ordinary is like where a minimum majority, simple majority, that is more than 50% has been received. Whereas special resolution is where more than 75% have to vote in favor. But this 50 and 75% is computed based on the total number of members present and voting, not exactly on the total number of members. So those members who are present and who are voting, only among them this ratio will be computed. And this is stipulated under section 114 of the Companies Act 2013. Now let's look into the types of general meetings. We have just seen that ordinary businesses are transacted in an annual general meeting. So annual general meetings are the ones that is annually for every company, and that is dealt with under section 96, while any other meeting which is held during the year is termed as an extraordinary general meeting, which is dealt with under section 100. The first annual general meeting of a company after its incorporation shall be held within 9 months from the end of the financial year, while subsequent annual general meetings may be held within 6 months. And EGMs can be held at any time by the board of directors. However, even at the requisition of the members who are holding at least 10% of voting share, an EGM can be convened. Now, before we conclude, there is a filing of a report on annual general meeting that is to be filed in form MGT 15, and this is applicable to all listed companies only, and this has to be filed within 30 days of the conclusion of AGM, and this contains majorly the summary of the proceedings on the AGM and on the decisions which have been taken in an AGM. So this is all about general meetings.
Do subscribe to Virtual Law and stay tuned to more explainer videos on the company law. Thank you.